morning. We'll now begin the technical meetings for the International Seminar Brazil European Union, the exchange of experiences in e-justice. We would like to inform you that the attendance registration will be made through the link made available in this virtual event. We would like to announce the panel of honor. Special Secretary for Programs and Research and Strategic Management of CNJ, Marcos Gomes, Auxiliary Justice of the Presidency of the CNJ, Alexandre Donati, Director General for Coordination and Administration of the Austrian Court, Martin Schneider, Professor of Law from the University of Vienna, Eric Schönhofer, and the National Justice Council would like to thank the presence of the authorities and the participation of you all, ladies and gentlemen. The Counselor of the National Justice Council, Auxiliary Justices from the Presidency of the National Council, Dr. Porsche Hendrik Tops, Head of Division of the System for Registries and Information of Estonia, Giro Menen, Director General of Law and Constitutional Law, Civil Law and Digitalization of the Berlin Courts in Germany, President of Justice Courts, ladies and gentlemen, speakers, and all of the participants following us through the channel of the National Justice Council on YouTube. The presentation of the program Justice 4.0 has as a purpose to publicize the program of digital transformation and implementation by the CNJ in terms of delivery and innovation materials and terminology. So we give the floor to Dr. Alexandre Bonacci for his initial remarks. Good morning, everyone. Dear friends, justices, dear authorities, public servants, it is with great satisfaction that I'd like to greet you all on behalf of Minister Fuchs this morning on the headquarters of the National Justice Council, and to all of those who follow us through the YouTube channel. This is part of a broad project from the National Justice Council with the European Union to promote exchanges of information in digital justice. We'll start with the panel on the status of digitization of the European Union, and we will present about the initiative the Brazilian initiatives of the Justice 4.0 Justice under the presidency of Minister Fuchs and the National Justice Council. Our first speaker is Dr. Martin Schneider. He is a consultant for information technology in businesses. He was head of the Department of Legal Informatics, Information and Communication Technology at the Austrian Federal Ministry of Justice, and he is a professor. He's a lecturer at the University of Vienna. He regularly lectures on legal informatics and is the author of countless publications. In 2004, he received the Legal Informatics of the Year Award and the Lifetime Achievement Game Changer Award in 2021. He is a consultant in the Council of Europe on e-justice and human rights since 2021. Dr. Martin Schneider, you have the floor, sir. Obrigado, bom dia, senhoras e senhores. Estou muito feliz com essa possibilidade de conversar com vocês aqui a partir da Europa em um evento tão interessante com um público tão distinto. Eu também já trabalhei como procurador na minha carreira e eu vou compartilhar a minha apresentação com vocês.
Sorry, I have first to start my presentation. My PowerPoint
Eu vou compartilhar.
Sorry for the delay. So now it works, and I'm going to share my presentation. Now it should work. Sorry for the delay again. I'm going to report today about e-justice in Europe and e-justice in Austria. I'm now coming first to Europe. The basis, the history of legal information in the European Union and also in Austria was legal information, which started already in 1965 with the CELIX database, which was made public 81, and 2004 it was given a new program which is called now Eurolex. And what's interesting is that 1st of July 2013, the publication of laws in Eurolex got legal effect and replaced fully paper. To compare, in Austria, we started in 2004 with the publication of laws, legally binding, and Germany will do this in the beginning of next year. E-justice in the European Union is covered by a e-justice council working group, e-justice and e-law. They cover the e-justice portal. I'm coming to this later on. And the topic of e-justice with legal aspects and also general topics of e-justice. And also cares about the official journal of the European Union. And there is also, besides the European Union, there's the Council of Europe. There you have a working group since the 1970s. And since 2002, to a European Commission for the Efficiency of Justice, which might be interesting of you to check this, because there is a lot of comparative statistic and compare of different e-justice solutions and court systems over all Europe. You will find in my presentation some expressions which are underlined as in this one here, it's the page, and there are behind this underlined expressions are links which you can click, and then you come to the web page. There is also, let's say, a kind of department undergroup which covers digitalization of justice. It's called cyber justice, and one of the topics handled there is the use of artificial intelligence. And to mention, I forgot at the beginning, Council of Europe comprises 46 member states and 6 observers. Inter alia, it's Australia and the United States, and also the policy. And back to the European Union, the basis for e-justice is an e-justice strategy. You again have here a link if you want to look into this. And the e-justice strategy says, okay, one of the principles is digital by default, once and only principle, which means that everybody has to enter data only once, and it can be used by, let's say, a citizen for all other needs and applications. And the objectives are access to information, access to justice, and of course, communication between authorities. On the basis of the e-justice strategy, there is an action plan where the details of e-justice can be found. I think the most important is the interconnection of registers, which means that you have access to national registers, land register, commercial register, insolvency register, for example, in the different member states with one application. And of course, access to legal information, questions of artificial intelligence again. And I think the most important building block is the e-codex, electronic communication in the field of justice. That means that electronic communication is possible between citizens and all member states and also to the European Union. The Justice Portal is an access point for citizens, businesses, to all the services of the European Union, access to law, information about the different justice systems, and, as I mentioned, register interconnection. And of course, also access to applications, for example, the European Payment Order and as well e-codex. So every citizen, European citizen, had access to more or less every member state's justice system via this portal. The principles of European Union e-justice is decentralized, which means no central components. The whole network consists of the member states which are interconnected. No no obligation to participate, which means that is all free if a member state takes part in one application or not. There are two exceptions, which is the business register interconnection and insolvency register. There are regulations which oblige member states to take part. No harmonization of national systems because it would be too difficult to standardize all legal rules. So it stays with the legal rules of every member state. But of course, there are interconnections between them. Again, two exceptions. There is a European payment order and a small claims procedure, which is unique in the European Union. And the Commission also finances projects with grants. And I'm coming on, as I said, to the most important building block, e-codex. It's an acronym for e-justice communication via online data exchange. It's a kind of European legal communication, which means communication between everyone within in the justice area. It's a so-called large-scale project to improve communication between the member states in the justice area. It was a consortium of 23 partners, including the European Bar Association, Notary Association, and also Open Software Standard Group. And Austria had the possibility to lead the technical part of the system. To understand the architecture, very simple, you see at the endpoints are different applications of different, also the same member state. And then you find a connector and a gateway. Connector and gateway have the duty, the task to standardize the information and secure it with certificates. And the standardized and secured information is sent to the other member state, gateway and connector, and there it's again check the certificate, the authenticity of the message, and it's also brought to the standards of the receiving member states. So you see a fully decentralized system with no central components, but where the possibility is given that all member states have the possibility to communicate with each other in a structured, standardized, and secure way. On top of this e-codec system, a lot of pilots are already installed. The European Payment Ordner, small claims procedures, interconnection of commercial registers, and lots of legal assistance between member states, lots of application covering this field. But it also serves for communication with the European Public Prosecutor's Office and also the Eurojust, the European Union Agency for Criminal Justice Cooperation. The target of the e-Codex regulation, you have again a link here on top of my presentation if you want to have a look into the regulation. It's to create a standardized, secure, and structured data exchange, as I already said, and e-Codex should be established as gold standard for future electronic data exchange in Europe within the judiciary. And the content of the regulation is most important point is that maintenance and further development of e-Codex is transferred to an European Union agency, the EU-LISA, because it's not anymore possible that it is maintained by the consortium of member states. It should be transferred until 2023 to this agency. And the scope of the application is defined, which means data exchange in the civil and criminal matters, and to establish a codex as preferred solution, but without obligation. It's still possible for, let's say, for elder applications to use other systems, and also if there are for special applications solutions which fit better. And the components of e-Codex are defined. Of course, the obligations of the participating authorities are defined. And what's for me very important is that in the e-Codex regulation, the independence of the judiciary is ensured. Which means in practice that this area has its own budget within the agency, has own secured resources, and also own management structures to ensure independence. Because the other part of EULISA is covering especially police cooperation. For example, you might have heard of the Schengen Agreement, which is also handled by EULISA. And there's a possibility of implementing acts, in particular for technical issues and security. And there's another regulation in preparation, which covers the digitalization of judicial cooperation as a whole. And here the principle of digital by default is stated. And of course, cooperation between the member states should be made easier, and especially barriers which still exist shall be removed by digitalization of this area. What means digital by default? It means that digital is mandatory for judicial authorities, and judicial authorities are obliged to accept digital applications. And on the other hand, for citizens, it's only optional. That means digital citizens can communicate digital, but also have the possibility to communicate still in paper. A codex has preferred solution, and also the payment of fees is covered, use of video conference, and the system shall be installed within a period of 8 years. With this short overview, I'm finished e-justice in Europe and coming now to Austria. The basic ICT organization in Austria is in this picture. You see the Federal Ministry of Justice makes a IT strategy and the management of the whole system. On the left-hand side, you see the part which is covered by courts, especially the higher regional courts play an important role in IT training and also maintenance of infrastructure. And on the right-hand side, you see our service provider, which is the Federal Computing Center, where we have IT architects, development teams, and of course, the maintenance and provision of infrastructure for justice. History of e-justice in Austria. We started 1980 with the land register, which is important insofar as, like it's in Brazil, the land register is constitutive. That means you get the property of parcel of land if you are entered in the land register. And already in 1980, this principle was transferred to electronics. It means when you were entered in the electronic land register, there was no more paper. Already in 1980, you were owner of the parcel of land. There are lot of other steps which you can read out, and may I mention only that in 1990, electronic legal communication was started in Austria. This is already more than 30 years ago. Where you see these little marks on the side, that were the prices from the European Union and other entities which Austria has won. And story goes on. 2013, Austria started with Justice 3.0. You have 4.0. You have Brazil is further advanced as we are, where we started the fully electronic digital justice, the paperless justice. Here you see the steps of legal tech in Austria. Justice 1.0 was the applications in silos. Then 2.0 was service-oriented architecture and was interactivity between the applications. And then we come to Justice 3.0, which means a fully integrated digital justice. Important was the cooperation with stakeholders. We had 100 stakeholders from the courts, from public prosecution, presidents with us, which worked out in different working groups, the components of Justice 3.0. And here, and I'm close to the end of my presentation, you see a fully digital courtroom. What was important for us is that the techniques, the digital tools are available for judge, for the parties, for the lawyers, but they don't dominate. So the people are, the persons are in the center and they act, and the technology is available but doesn't dominate the courtroom. What was the essential points, essential items which made Justice 3.0 successful was the participation of all stakeholders of justice and also lawyers and notaries. And second, what was not planned but was given was, of course, a pandemic because judges found out that living with digital justice helps them very much to keep track with their work also during pandemics. So this was my short overview about e-justice in Europe and Austria, and I'm happy if you have some questions to answer them. Thank you for your attention.
Thank you, Dr. Schneider, for your presentation. which provided a very good overview of the situation of e-justice in Europe and in Austria. Without further ado, I'd like to give the floor to Dr. Eric Schneidhofer. I hope I have pronounced your name correctly. And he is a doctor since 2008. He has been associate professor at the University of Vienna in the fields of legal informatics, international law, and European law, and where he teaches and conducts research in several areas. He's also head of the Informatics Center in Law. He has worked in the public administration. He has many years of administrative experience in the European Commission, Austrian Federal Academy of Public Administration, member of the Austrian Council on Robotics, Artificial Intelligence. He directs the working group on legal informatics at the University of Vienna. He has published numerous articles on AI, robotics, and law. Dr. Eric, you have the floor.
So, thank you very much. It's very difficult to speak after Martin Schneider about e-justice in Europe because he said everything that you can say. What's left for me is mostly some academic reflection. And I move to my slides, so hopefully it will work. Can you? Yeah, thank you. What I will do is mostly seen from academia, where the e-code was a discussion in the 1990s already, and with so many ideas about artificial intelligence, automation, and so on. But then, so it works. Yeah. Sorry, I go back. So sorry. Just the overview. So now I have it. So yeah, you see a bit academic reflection about e-justice, then digital justice versus analog justice, what is changing, and then some topics Martin Schneider didn't cover is what about privacy, data governance, then also justice is public, but still not everything, then also legal information covered together with that, then a lot about IT security is important, but nothing new, and then the hardcore, what you see also in Europe is electronic file, yes. The paper file, electronic file, a strong topic because everything is then there, the communication part, automation part, document delivery, and so on. And last but not least, I will speak about the automated judge, not a robot judge. Automated means that it's a bit like a car. You have some tools that help you, that assist you, but not replace you. If we move on, yes, Martin Schneider said, so yeah. We started in the 1980s, actually with something, the registers, land register, then business register. A difficult way to do actually, and also the question what's about security. And then nowadays, we moved communications, what you've seen, the e-cortex is a part of it. And then nowadays we have a lot about video conferencing. Also then we speak about robot judges. Then quite strongly state analytics, because it's not like in the United States that we have such big files, gigabyte files, but still it's growing and you need some tools. And also, our Estonian colleague will speak about that, blockchain registers, not as a new tool, is discussed. And the EU is different. It's very complex compared to Brazil. Not an easy country either, but still we have a bit more people with more member states, and you have more languages. And a lot what Martin Schneider mentioned is how to communicate with someone in German, but the other speaks only Italian. There's a lot of markup of information, semantic information, distributed via these electronic forms, intelligent forms. Sounds not so really special, but it's very important. Then also, But we have for the justice systems, Austria is lucky there has only one, but Germany has 16. And you have many particularities. So very difficult to adapt this. And European Union can only advise, promote, support, but not more. If you see here why we do it, why we need it, actually we are, or many people in the justice sector are still happy with how it's working now because it's quite well developed. And digital is somehow not always so easy to take. Yes, I'll say always digital doesn't go away, so we have to accept it. But still, what kind of solution you have? We had some kind of meetings with judges, and when they spoke about robot judge, yes, they said, yes, we're not just applying the law as it is, what a robot may do sometime. We are much more also a communicator, a facilitator, a dispute settlement provider. That's much more. So how we do it, it's on one side the society says we have to do it. Then on the other side the workload is changing. On the one side you have more and more easy cases, this kind of low value, high volume cases, consumer cases. You can do it by arbitration like in the United States, or you say, yes, the justice system can also support it. Then you have the need for more justice because people are more and more asking where I can have my judge, my review, my legal review. You see it in Europe, particularly when it comes to administration, where it wasn't the case, and now it's much more the case. So there's a strong need for that. So therefore, it's quite some kind of a hybrid settlement. If you can afford it, if you can do it, you do it on-site. If not, if it's not possible, you do it online. It depends very much also on the people involved. But if you do it, it's not so easy either, because if you see, the main problem is, if you see digital justice or analog justice or discrete, steadily information, the problem is the information. As a judge, you need all information that's available, some kind of a holistic picture. When you use this kind of digital forms, it's never complete. And you see it by video conference, you see the picture, but you don't see the room, you don't see the environment, what may happen there, you don't know. And that's also a problem with all kind of information, documentation in the digital format, how you achieve it, that's it's the same. And when it comes to people, it's even more important to see, yes, how I accept a person to be the person if it's coming, if you know it only online. That's the difficulty. And also when you see, just to refer a bit to Hans Kalsner, a famous philosopher, also well known here, the court as such, we were yesterday in your courts here, very impressive, but still this 33 ministers of justices of your higher court, yes, who says they are the higher court? That's abstraction in the sense of Hans Kelsen. So in the real world, it's easy. You say just there's a building, you have security, but when it comes online, very sure that it's the higher court or not. And here, what kind of solution we can offer? It's mostly that you have to go digital, meaning you have to provide security, electronic security, and it means also that you have not only on the one side, what you're doing very well here in Brazil, that judges say, yes, we have these tools, we may use it. More and more, you have paralegals are supportive, helpful, documentalists to do it, Grafs chancellors help out. The security is improving. So it's this is one side, but the other side is also then how I move from a nice building, everybody knows it, to a website where they say, yes, I'm now the Federal Court of Brazil and nothing else. The whole building is gone. How do you see the whole respect for this court? Difficult to do because we don't need it anymore, because the judges can work at home, you have Zoom conferences, you have archives, databases, and that's it. Sure, in the very end, in the hybrid code, and that will be, you still keep the house, yes, because for representation, but also for meeting, you need that. But here it's just a question of training to do that. But what's more important is also then what's with the other clients you have, the advocates, then the accused persons, witnesses, the public, how to include them, because even in Europe, not everybody has a digital electronic signature. So how do you establish the identity? When you are in court, on site, use the old English method. Person is what you say is to be, and you check it. And then you know it, it's sufficient for your purpose. But online, quite difficult. And if you use electronic signature, it's a possibility, a good one, but still not everybody has one. And that's not easy, actually. In Europe, we have this kind of IDAS regulation and moving to electronic identity. Actually, a quite nice concept, legally speaking, from technology-wise speaking, but on the other hand, quite many don't have it or don't use it properly. So if we would ask for, in Austria or Germany, we do it all electronically, and please send me your electronic signatures and kind of proof, no. It will not work easily, let's say. So therefore, and just refer when I had some research on proof, a lot you can do by consensus. So if you know each other, you don't need this electronic signature. You may have other possibilities. For instance, like in Austria, a witness taking can be somewhere remote, but it has to be in a courtroom. Maybe you have done some others. You go to a solicitor or a notary, where they establish the kind of identity proof. That's also a possibility. But consensus is quite strong. And in Austria, in the COVID-19 period, the cooperation between advocates worked quite well because they know each other or they're in a closed system. So going public, including everybody, isn't easy in this system. So for the next would be, I already said it a bit, we changed that because the society is changing. Okay, yes. And higher capacity. It's not so much the number of cases, it's more the complexity of cases. And then also the question what we do with these easy cases where there's no real money involved, to say low value disputes. What we do with this? This is a challenge. And you don't have more judges. You don't get more judges. You don't get much more money. You don't save money with IT. You spend IT money. The only savings are, and it's mostly communication, postal fees. They're the real savings. The rest, you spend on IT. You have mass personnel on this. You may have done more IT people. But what is need is also, and that's where the automated cases come in, you can do much more with automation. You produce more documents, better documents, where you don't need the full expertise of a judge because it has done it before. It's a repetitive case, a similar case, and here is a huge potential. So, and then as you know, you have more complex cases, you can spend more time on that. So, and as you see in Europe, in Austria, we started in the 1980s, and that's 40 years. So it's a long-term move. It's not just from now and then. It takes time. You have to be patient. You see it also in the projects in Europe where you have more resources, more potential maybe, but still it takes time, and also people involved, and judges decide how they would like to provide justice, and they have to find a consensus. So we can't say, yes, now we take away your paper files, and then you have now the laptop, and that's it, and you stay at home, you don't come to court anymore, you can't do that. That's just a consensus. And also the advocates, the public has to accept it, how you do this. Here's a bit virtual court. Yes, sir. I would like summarize it only a bit. It's a lot of security, yes, sir. everything you do has to be secure, yes, communications, then also the emails, the identities, then your website shouldn't be hacked, then your documentation, your file system. If there's a successful hacking, you are in serious troubles. So you need a lot of this kind of IT security people. When it comes then to the other topic, when you had it in the courthouse, the files were quite safe. Yes, you had a security, you had an archive, but now you have a website, a cloud, a server, and it can be accessed worldwide. It can be hacked, and this obligation of data security is then particularly important when it comes to the privacy. And in Europe, we have the European Data Protection Regulation that has a nice set of rules. It doesn't apply as such to the judiciary. So you keep your own rules, but modify them to data protection concerns and respecting human rights, in particular the privacy right or also the data protection right. So what you have here as special problems is mostly openness. How open I am as a court. Is everything public? Can everybody see the file? There's some kind of open government in the United States. They can see every police file as a citizen. That would be real openness. Going to court and see, I would like to see the file. Actually, not much heard, maybe in Scandinavian countries in Europe. Here also not. So we have some kind of an openness, but it's restricted, saying we do it for the proceeding, public proceeding, if there's not a family case, and we publish the decision. That's the compromise, it worked quite well. And there was another compromise. We're not a common law country. We publish everything, also the names. Nowadays, you don't publish names anymore if there are natural persons. Then something we have a bit to discuss also, is kind of also privacy is involved, how much you've been involved in the public discussion, where Brazil is quite good, you have put it on social media, people may comment on this and that, there may be discussion in the media. This kind of reflection has also a lot to do with privacy, because in the very end, those who are concerned may not be interested that the whole life and the whole file is then discussed in public. How to deal with that? In Europe, besides the GDPR, we have the special directive for the law enforcement sector. So it's a unification of European rules on that. When it comes to the criminal sector, then the special rules concerning the Europol, Eurojust, allowing much more cooperation. But the main task when it comes to privacy is still in the national codes on procedure, civil procedure, criminal procedure, police laws, and actually they are quite data protection friendly, so I haven't to change that much. But still, some modification is required. And as you know, this kind of privacy is quite relevant when it comes to access to documents, so you have to respect that. So it's actually a quite complex data work. Here I mentioned publicity is also a right, human right, like here. Here we have both we refer to the European Convention on Human Rights or the Charter of Fundamental Rights of the European Union. So it should be open to some degree and some balancing between publicity and privacy. And anonymization is now standard also from the Court of Justice of the European Union since 2018. Before, also personal names were published. So you may know Costa or Bosman. They got famous because they were involved in the case. Nowadays, it's over. Then, for the video of court proceedings, I participated in some experience in Austria. And what we have also noticed that if you are fully public with the videos, then witness taking is difficult because the other witnesses may know what someone has said. And then it's the question how long you keep it online, and if you delete some parts for privacy reason may be necessary. So we are a bit running short of time. So it's information systems. Just to say a bit what we in Europe has done, as Martin Schneider mentioned, it was the justice sector who developed most of the databases, who were then combined with the databases on laws in legal information systems. Also, Ölex is a part of it, or the Austrian system, RIS. And as you know, there's another development in common law countries and also developing countries, where the academic sector is strongly active with the legal information institutes. And that's still quite relevant, important, because they provide access in countries where the public sector can deliver that easily. And one other development is the neutral citations. I don't know if it was a problem here, that in Europe we had citations based on citation codes by publishers. And now that moved to a standard neutral citation by the court itself. That's called the European Case Law Identifier. Maybe helpful also to use it here to identify the court. ID security, you see that's many details. I will skip a bit this. But all this, what's mentioned here in this nice graphic is important. Secure communication, secure hardware, secure software, yes. Easy to say, but still in the present worldwide climate, hacking is quite common, so please be aware of that. You provide a very high IT security, otherwise you may be lost, because hacking of a court server, or even more, it's things that shouldn't happen at all. But very important is also the other side, that they respect security, the clients, the advocates, that you in the very end follow a standard. In Europe we have this kind of network and information security rules, and they are adapted for the public sector, but also now for the judiciary. So it's we have done some homework and seem to have worked so far. Now I come mostly to the core, and but I also mentioned it quite often, electronic archive. If Gareth from Germany will then speak about it, it's the hardcore in Germany. Everybody should now from paper to be a digital, electronic. And you see Germany is a country with a very developed paper file. They have people doing it, so for the judge it was actually a situation that couldn't be easily improved. So nowadays, he has an electronic file. It's hopefully same quality. But the other problem that's also to be discussed in Europe, ministers of justice like to save staff, support staff of judges. So they say, if you have the IT, why not do it yourself? Yes, and maybe not so strong problem here. But it means also that motivation to go digital is a bit reduced if you have then to do additional work, if it's not an advantage. So in the file you have everything, and it's very important because even very good judges with a good memory, they can't memorize every detail, and in Europe maybe a judge has about several hundred cases. Here they have several thousand, so memorizing every detail is impossible. But with the file, you can have a good memory of all this with narrow details. And the main problem is when you have a paper file, you have a haptic element that works quite well, particularly when you're used to it. And doing the same electronically, it's training, you can get to it, but maybe not the same. That's a bit the problem. But you have other advantages. You see the size. You say very thick files, don't care, it's not so relevant. Then the communications. A lot is automated. What was before some real work, yes, going here, there, please send a letter, get a letter, archive it. That's much more difficult. then also access to the file, what before some real work is now, can be done automatically. Yes, you just give access to documents that are available to everybody, to the parties. Then you can structure and restructure. Also knowledge graph is some kind of a term of academia. Then you can all use information retrieval tools, so search for words, structure, metadata, and also, that's more an American tool, e-discovery, where you have gigabyte files, where you can really analyze gigabytes of documents. So that's a real advantage. The problem is how I get used to that in the same way. And some element I also like to use is how many screens or, let's say, papers I need on my table to manage a case. And then we see, I've seen it from Spanish colleagues, they have many papers around on the table and they need it, they know where it is. How do the same with computer screens? You only have one or two, not more. You don't have a video wall, but that's what you need, that everything is there. So how to do this? And that's a bit a problem because hidden screens, not so easy. So it's maybe some kind of combination between paper, online works quite well, and printouts are here not so common, I heard. In Europe it's very common. It's also addressing a bit this problem, yes, so that you don't have everything easily available. And also it's a learning process, so get used to electronic files. So last but not least, there is some remarks about Germany. Germany is now working very hard on that, and they like to have at least some discussions, some kind of a PDF version of the paper file, a very similar version of the paper file. They can print it out and you have your paper file again. That's one of the many applications, we'll see. It's discussed as an annual conference in Germany, the EDV Gerichtstag, and there is quite a big event, 1,000 participants every year, and they discuss how they do this. And in Austria, they have decided for a different version. It's more IT-adapted version. So they use how you would do it with IT. It's mostly some kind of, when you see Explorer, yes, you have a table of files, and that's it. And it's quite similar with added information like the paper card we used to do before. So you've given up some elements of the paper file, but they still have a quite developed structure. And then what they also use, they buy some tools, in that case from LexisNexis. They identify automatically citations, reference in the document. So for a judge, you can read and see what citations are there, there's some judgments, literature, other documents, and see if it's relevant or not. So much easier browsing through the whole document file. And then also e-discovery is a possibility. So knowledge graphs, so more automated tools are not so much common, but will come. The production of automated documents are also very relevant. So, and when you see what Martin Schneider mentioned, is quite strong in this case here, the money order, yes. For the judge, it's just a click and then the money order goes out. Nothing has to be written then. That's very helpful. Then in European judiciary, we have many, many forms that you can easily transfer to this here. More difficult is that you, let's say, get a draft judgment because I do some data analysis and have all the data and then see, yes, so I may decide this case, a possibility. But that's difficult because there's one problem. As you know, the lawyers, they write and write, they don't structure properly, they have their own way of writing it. And if they would like to do it in XML form, really structured, fine, but they don't do it. So we have to do some research to do it by automated means. The automated judge as such will come, but not the robot judge. So compared a bit with cars, we get more and more nice tools, and the same will happen here. So, but still, and that's also important, the focus. If you do it automatically, then at least there must be some very quick review, fast review by the judge, as in Austria, other countries. But the final decision should be yours. But there may be some decisions going out in your name done by your robot. It's a possibility. It's not so bad. Because it's always a question also of acceptance of the parties, what they say. So it depends a lot how much you can do by automated text analysis, and we can speak maybe later about this. Also relevant where anonymization, getting some metadata of the file. There's a lot that's happening now in Europe on that, and also in Austria. So I would like to close. Just one last remark. Legal prediction, also a tool of the United States, where you have the text corpora of the court and all the data, and you say, yes, I would like to know how I will decide. That they have done forever, and now they have the tools available, and now they say, yes, this court may decide this case according to its case law, so and so. And this is not so bad things, because it's advice required by lawyers, by advocates. Then you can do a lot of artificial intelligence, and the results are quite promising, let's say, better than normally a judge will do it so. And the question is, just as a discussion point, leave it to the attorneys and the science people, or say, yes, we order as a court service. We give some legal advice to the public, say, if you come with this case, the chance of winning is 50%, 80%, or 10%. Would be quite useful legal advice. So, coming to the conclusion, it's a change of culture, but that you know, it takes time. You don't save much money, actually. You spend money, you may save it in other areas, but in the very end, it's the same. But you have then high efficiency and also your response to the needs of society. The people will say, yes, I would like to file a court case. Why not use my mobile phone, fill in a form and send it to the court? Why not do this? May come. And this is also what's important. So you do it, respond to the new needs of society, but still keep what's important, delivery of justice. So thank you very much for the attention. Sorry for the auto-translated Portuguese. Hopefully it was a bit helpful. And thanks for attention, and I open for questions. Thank you.
Professor Eric Schweighofer, thank you for your presentation. We can understand that the challenges of digital justice are not restricted to Brazil. They involve the whole international community. So these challenges obviously involve aspects related to security as well as cultural aspects, with the transition from physical forums to the provision of online services. I'd like to point out in your presentation, you mentioned the challenge of electronic identification, and coincidentally, a respected lawyer, Dr. Lemos, who is part of the national consultative group upon invitation by Judge Fuchs, he published an article on the failure of analogical identification and the need for a new electronic identification system in Brazil, increasing security and protection to citizens. And so thank you once again for your participation, and we will move on to the second session of our day. We will now begin the technical meeting on Justice 4.0 with. So we will soon continue the program. all for your attendance. This seminar will culminate is the culmination of a project that was started in this administration towards integration between European Union and Brazil on e-justice and digital transformation. The judiciary in Brazil is a model of digital transformation. We are at a level of digital transformation that is way beyond the other authorities in Brazil at all levels, and we will advance greatly by the end of this administration. The main deliverables are scheduled for this quarter. I am sure we're going to have a very dynamic and technical presentation, and this is the tip of the iceberg. I'd say that the major projects will be presented to society and the judiciary in the next quarter before the end of the administration of Judge Luis Fux. So I wish you all an excellent panel. I'd like to invite Judge Fábio Porto. Good morning. Thank you, Marcos Livio, our Special Secretary. The idea of this panel is to be very brief, but I will like to ask for my presentation to be put up so that I can provide an overview. We are already scheduling another occasion for us to dive into all these projects at greater depth. So this is just an overview of a project. We will not go over all of the objectives, but I'd like to point out two: the digital transformation of the judiciary branch and the need to integrate all courts by means of a digital platform. These are major goals of this program, and for this to happen, we had to prepare a range of legal norms and acts. We have produced 1/3 of all the norms for the National Council of Justice. This was necessary in creating this environment that we call microsystem of justice, digital justice. And we also developed a range of programs or solutions that we called structuring solutions, which provide a framework for the 4.0 justice program. And so this structure, this framework, we are going to talk about some of its components, but I'd like to point out training or capacity building, not only of judges and staff, legal staff, but also in terms of IT. We are qualifying professionals, we are requiring qualification in recruitment contests, because in Brazil and in the world, this is a natural trend, an irreversible trend, and we are progressing quite significantly compared to the rest of the world. And so this idea of the 4.0 justice program and this systemic evolution that we have, and building this new reality, and to this end we have a range of resources that have been allocated with the hiring of 114 staff, of which 98 are exclusively dedicated to the IT area. We are also recruiting several companies and entering partnerships with several universities.
Pois é, nós temos até 12 horas, nós não vamos atrasar, então eu vou correr
We
ainda
have
mais.
only until
Tentando entender
noon.
a letra,
We have
perdão.
until 12.
Mas já
We
foram 12, meu
cannot have
cronômetro
any
está
delay.
disparado aqui,
So
faltam
try
40
to
minutos para a
speed
gente
up.
encerrar, porque nós teremos uma
We'll
segunda
have
etapa
a
aqui na parte da
second
tarde, às 12 horas, tem
part
início,
of
então nós
this
vamos
afternoon
acelerar
and we'll
bastante
start
aqui
at 12. So
esse painel,
let's
porque não podemos
speed up with this
atrasar
panel because
12
we
horas com
cannot
a abertura.
uh,
Então, passando en passant aqui,
accommodate
todas
for
essas
any delays.
contratações
So
ensejam justamente a evolução desse
contracting
programa, a possibilidade dele se concretizar. Isso é só para os senhores
was
terem uma ideia
made
do tamanho da equipe.
possible
Essa
into this
equipe está
program. So
dividida em
just for you
vários
to know the
eixos.
size of the
Alguns
team, this team is
eixos são
divided
eixos
into several
transversais
axles.
que
Some of
possibilitam,
which
a
are
atuação
cross-cutting,
múltipla em
which
diversas
provide for
etapas
the
dessas pessoas
multiplicity
que estão
of
atuando no
activity
programa.
of the
É um
persons
projeto de fato
involved
de longo
in the
prazo.
program. It
A
is a
previsão
long-term
dele de se
project and
encerrar
its
é em
uh,
2024. Ele está
forecast for the
antenado,
closure is
né, com
2024.
planejamento
It's actually
estratégico,
in line with
com a
the strategic
estratégia
planning
nacional
of
publicada na
the
resolução,
national
por
strategy
exemplo,
published
125.
under
Então, a gente tem
Resolution
várias entregas para esse ano,
325. So we
próximo e
have
para o
several
seguinte,
deliveries for
que
this
estão
year and the
projetadas
next
aí
and the following,
nessa,
which is the
nesse
last one.
escopo
And these
do
are
projeto de longo
forecasted
prazo.
in this
Bom,
scope of
começando
a
propriamente
long-term
naquilo
project.
que é relevante, né, o
So
primeiro
going
grande
straight to the
projeto, que eu
relevant
diria que é a
topic
base
at hand,
fundante
the
de todo
major
o
project, which
microsistema
is
de
the
justiça
foundation
digital,
of
é a
the
plataforma
system
digital do
of
Poder
e-justice,
Judiciário.
is the digital
Essa
platform
plataforma,
of
a
the
gente tem um
judicial
vídeo, eu não vou
branch, the
passar, tá,
judiciary
em
branch.
razão do tempo, mas
We
ele
have
está
a video. I will
disponível
not
no YouTube. Ele
show the
tem
video
essa
at this
visão
point due
e
to
aqui
time constraints, but you can find it on YouTube. And I'd like to call Dr. Adriano uh, so that he can tell us in very uh, succinct form and a very summarized manner what the platform is all about, and I can pass the slides as Dr. Alessandro explains. Good afternoon, everyone, or good morning, everyone. The digital platform of the judicial branch is a public policy established by Resolution 325/2020, and it aims to solve a practical problem of the Brazilian reality. We are, as you may know, a federation with over 90 different courts. With the with the establishment of the e-justice courts, we had many different initiatives of the different courts for solutions for electronic format without a proper oversight by the National Justice Council and the consequent a waste of public funds in the different parallel activities that were not duly coordinated. So the digital platform of the judicial branch aims to tackle this problem in particular. So we can define it as a public policy for the development of a community cloud development of computer solutions for electronic procedures. This is what the platform aims to establish. When we talk about cloud, providing you more concrete information, today the justice system has solutions that are in the AWS cloud, which is the Amazon Web Service cloud. And to provide for this community development of interoperable solutions for electronic legal procedures, we've developed in this platform a group of structuring services, which is a set of standards and technologies and tools to develop national solutions aimed at the electronic legal procedures and to integrate the services of the electronic justice or legal procedures that already existed in the different courts of Brazil. Our colleagues at the panel will, throughout the panel, talk about different systems and services that are found in the platform. And I could mention, for example, the unified login, the SSO single sign on, which makes possible that the users are authenticated a single time and allows the user, once authenticated, to access all systems integrated to PPJ without the need of further authentication solving a classic problem that judges used to suffer of having to memorize millions of passwords. I'll give the floor back to Fabio. I'm very sorry for interrupting you, but we have a short time. So the idea of the single sign-on is what we have in the screen. This is the marketplace of PPJ, and as Dr. Marcus said, the vision is for the consolidation of the systems. And when we started this project, we had 64 procedural systems in electronic format in the country. Now we have 39, and the idea is that starting next month we'll have only 14 systems. So we are trying to integrate and reduce the scale, trying to organize and orchestrate the efforts in that direction. Of course, what we desire, what we wish for, is a single system, but it's not immediately possible. But and to collect and integrate all of this data and collect all of this information, we have a codex. It's not the e-codex that was presented here already. It's another codex. So explain to us very briefly what the codex is. So I'll try to summarize the context. This is a great project of infrastructure and treatment of the data that we have in the judicial branch in Brazil. This is the source of information that makes possible for us to have access to uh, the different procedures that are contained in other systems. So this is uh, one service that provides service to other instances, and it also treats of how the procedures are seen abstractly into the system. So one of the procedures in the country is within the codex, and it creates this representation, which is an object with all of the uh, structured data of the project. This information is consolidated in the cloud to be consumed by any system. But for us end users, we can imagine that soon, when we have a claim for an extrajudicial information, the judge can have access to the content of that procedure in its current state. But not only that, through this pathway of data, we can deliver multiple services such as artificial intelligence, statistics, integration of procedures. It's a new environment. And this is the baseline. We don't consider drinkable water in the sanitation services, but when you don't have it, you can feel it in your health. So this has generated part of the delays that we historically had in the judicial branch, and this is the reason why we speed up the systems and make quicker deliveries with more advanced technology. Within this environment, we have Synapses, which is a national platform of artificial intelligence. So this project was created in the Court of Justice of Rondônia with this collaborative effort made possible by BDPJ. So we have over 111 artificial intelligence projects, and they use this volume of data, and we really rely on large volumes of data to train artificial intelligence. So the Synapses integrates with Codex to bring artificial intelligence services with the flow control from beginning to end of the whole implementation effort. Here in Brazil, we're not trying to have automated judges just yet, but we are trying to automate the delivery of data to justices so that they can receive the platform and receive feedback from of suggestions from the receivers, so we can retrain and redirect the information to the data that was utilized. So we have the national platform that guarantees the algorithmic transparency, which is already available for all courts to replicate the experience of more advanced courts. Following in that line of thought, we have Data Jud, which is a database for the judicial branch in Brazil. We have this repository from all states, and this was a brilliant work from Dr. Ana Aguiar. So it was a work of sanitizing, cleaning up, and treating the data of this database, which allows us to have a PI panel, a dashboard, as available to all judges, so that they can compare their units to other units according to data and the rates available here. And the idea of the codex is when it's 100% implemented, the courts will no longer need to forward the data from the data JUD. The codex will feed data JUD. This is the vision that we have for the future, and it will contribute to our data link. So this would be the set of elements that compose the basis of the structuring services. This is another tool, is the jump tool. I'll talk about it very briefly, and it's added to the codex because once you install the codex, the courts will have at their disposal this tool, which is a mining a procedure mining tool, and which I through which I can identify every bottleneck, time of procedure, how long this process has taken in a given server, why has it stopped, when and where did it stop, and when and how we can evolve in the administration of justice with technological tools like this one. This one is already available for every court that has the codex installed. Another tool which is fantastic, is Mandamus, which is a partnership of the National Justice Council with the Court of Justice of Roraima, and we could automate all of the so we use artificial technology to distribute uh, mandates or warrants, so we can have a picture or a snapshot of the assets that are being held, and these warrants are immediately inserted into the system and made available uh, to the appreciation of the justice. So Dr. Doroteo is online, and we have the sniper tool. I'll ask Dr. Doroteo to talk about it. Well, sniper is actually a great translator of databases. It translates every public and private database that we have in Brazil regarding the connection of persons and companies and assets as well, and they it actually draws a graph. It will be demonstrated in the video. It actually gives the magistrate a view of the fiscal group or economic group, and it can also support the whole judicial branch in the understanding of financial or complex financial crimes. Yesterday we had news that all of the baseline of the Federal Revenue Service is already indexed in the Sniper with automatic updating. So thank you, Dr. Doroteo. This tool will advance in the fulfilling of sentences and court orders. So this is the executive part is a major bottleneck of justice, and the report Justice in Numbers points out that fact. And one of the main points of the digital platform, and we have some presidents of courts here. We've incentivized its implementation and with many meetings, and the service portal will uh, will allow every single advocate or lawyer and members of the Federal Prosecution Service and citizens and justices to access every single procedure of the national judicial branch to verify if there are any subpoenas, petitions, identify publications in the Journal of National Justice in a single environment, a single platform that will only be used and only be feasible if all courts are integrated to the digital platform of the judicial branch, as Dr. Adriano said. It is a national policy established by Resolution 325. And in addition to this platform, which is the portal, we have the electronic household, uh, which will allow for an electronic citation of all companies and individuals. So subpoena may in the future be exception because everyone will be anyone will be able to be subpoenaed through this system. It's a tool that will be made available at the dawn of Minister Fuchs' administration. So all of these systems that we are showing you are within the context of the short-term planning, uh, which are to be launched in August and September of this year. We'll soon talk about the long-term systems. One of them have already a step available at this point, which is the national system for the asset management, which would allow us to have a vision of every asset that is seized. We're talking about 100% electronic procedure, so there are parts, documents, and sometimes even tapes or K7 tapes or old recordings that cannot be digitized, and it has to go to court. And this system allows for you to make the asset control of all of that. So we'll have the first version of this system, the first stage, the first phase will be implemented until the end of August.
When we will be able not only to register assets, but also accompany and keep track of these assets, allowing for more effective management and control of all assets that are at the disposal of the judiciary. Another system, Rafael, if you could talk about it, it's the pension system. The pension system also follows the logic of the digital platform with a borrowing of communication among systems, and so a range of information and fulfillment of determinations of federal justice or state justice, which used to be conveyed through letters or this will all be done now through the communication borrowing between systems. And so the path that is being built is that all the information that is part of the social security system will be brought to the system. And at the end of the cycle, with the decision through barring, this will be sent to the social security systems for fulfillment of the court order. And so automated extraction of data and automated fulfillment of court orders by the social security system. And so we have all these systems communicating and an environment where all the data of the cases are available to be consumed by other systems. And so we are able to increase the speed of procedurings, because in some states it takes months to obtain data from the social security system and a few more months for the court orders to be fulfilled. And we are now talking about milliseconds. And so this is a huge gain in terms of speed. Now, one of the systems that is also available on the digital platform of the judiciary is Renajude. Dr. Adriano, could you tell us about the evolution of Renajude while I run the video? Well, it is a system developed under a technical cooperation agreement with Denatran. So in addition to all the functionalities that judges in Brazil are used to, such as being able to do searches for automobiles, and with the Renajude, it will be possible also to look up and include or exclude restrictions related to the drivers or those conducting the vehicles. And so this it will not be available in the web version of Renajude, which will be phased out soon. So this version of Renajude for PDPJ was developed especially with a view to automation, so that courts can connect to the API that was developed for the system in order to enable the automation of everyday operations related to any issues involving Renajude. Thank you, Dr. Adriano. All this, we're going over it very quickly because there are several projects, so I apologize that we have so short a time for this overview. We will get into details of this on another occasion. I wanted to include another project that is also available on the platform, which is Criminal Query, which is the first step for us to get to a national frequently asked questions. And so, or fact, we are going to integrate the base of the BNP with the codex so that we can obtain this information not as a criminal history form, but this should help judges. It's expected to help judges, especially in the penal area, so that they can look up at national level if a defendant has any criminal history. And so we are going to talk now about long-term projects, no longer projects to be delivered in the short run, but projects that are being designed and with a view to delivery in a longer term schedule. I have Dr. Patricia beside me. She will tell us about Dr. Tricia, please. Good morning. This system is already up and running, but with the 4.0 Justice Program, the idea is to review this system, which needs to become more intuitive and responsive and functional. The idea is to include new tools such as active search, which is a demand by courts. We are already developing it. With the new SNA, we will have a much more agile and efficient tool. That was quicker than I thought. Thank you, Dr. Tricia. Another system that is already under development and also with a longer term schedule is the RPV system. And this is a system that we have an agreement with for the development of a major system with a view to inclusion and updating of these also their position in the list. And so this will be transparent and people will be able to look up on their mobile phones and this list of judicial orders, of court orders and court order debts. And so not only for, well, above all for the authorities that have payments to receive, they will be able to do their calculations more easily. And so we have a range of systems. Going over them very quickly, another system that is under development is the National Bank. Criminal measures and imprisonments. So it's a new concept of this bank, of this data bank. Well, historically, we had the BNMP 1.0 under the management of Justice Carmen Lúcia. So then we developed the 2.0 for monitoring of imprisonments, and now we are developing the BNMP 3.0, which is for criminal measures and imprisonments. And so what is different? What justifies the development of a new system? In addition to the natural advances that we expect in terms of usability, and we know that the current version sometimes fails. So with the new resolution, in addition to imprisonments, we will include measures, alternative measures to imprisonment, and also urgent protective measures under the Maria da Penha law. for protection of women victims of domestic violence. And so we will be able to manage all these measures more easily. Thank you, Dr. Adriano. The next one under development, Dr. Adriano, can you please tell us about it? It's the social educational system, which is also part of the concept of citizens that are imprisoned, but also those that are under a social educational measure, specifically the adolescents in conflict with the law. As Dr. Fabio mentioned, we already have a national system, a unified system to control the penal execution cases for the adult population, and we are currently developing the department in charge of monitoring of incarcerated population and social educational measures. Together with the IT department of CNJ, we are developing a solution that is similar to the national system, integrated with the systems that the courts use in their electronic procedures for the monitoring of social educational measures enforced on adolescents in conflict with the law. And to make this a reality, we conducted several meetings with all the courts. We had hybrid meetings, remote meetings, and in-person meetings to see the status, to look at the and analyze the status of each court in this national integration process, and how we could help each of the courts, the CNJ with its limited team, seeking to help, and we are, of course, trying to improve this communication. And all this promoted significant national engagement. I believe that next semester we will have a major revolution, a revolution where we will no longer act individually, we will be able to act collectively in integration. So all the courts will develop in partnership. We will rationalize costs, increase efficiency, and above all, will increase speed. This is the aim of the judiciary platform, and that's the reason for all the meetings and so many documents and plans of action and discussions on each of the points. So this is the idea underlying this major project, which is the 4.0 Justice Program. So we have actually been very brief, and you see, I always keep to the schedule. I'd like to give the floor back to our General Secretary for a conclusion. Thank you all for your attention. Congratulations to this panel, to all the members of the panel, and I would like to mention first our dear Tiago, IT Director of CNJ. Without him and his technical support, the projects would not be successful. Tiago is the man behind the scenes, always present in the backstage. And I'd like to thank Germain, who is the coordinator of the dialogue with the European Union, and all the experts from the European Union, Christian, and all the experts, Councillor Jani also, thank you for your participation. I wish you a good day, and we will soon welcome Justice Fuchs. Ladies and gentlemen, thank you for your presentations, and we will soon continue the program.
Ladies and gentlemen, good afternoon. We'll now begin the official opening of the International Seminar Brazil European Union Exchange of Experiences in E-Justice. For his opening remarks, we give the floor to Justice Luis Fux. Good morning, everyone. I would like, first of all, to greet my distinguished companions at the panel, His Excellency Ignacio Ibanez from the European Union in Brazil, dear Ambassador, our partner from so many initiatives, my colleague in the Supreme Court of Justice, Minister Fachin, uh, and now President of the Superior Court of Justice, Humberto Martins, President of the Superior Court of Justice, and also working in the National Council of Justice, Mr. Claudio Speldener, representing the justice from AGU, which is our friend at the Supreme Federal Court as well, in financial causes. Dr. Augusto Aras, Prosecutor General, he's on his way. Dr. Walter Schwenkner, Secretary General of the National Justice Council. Marcos Livio, Special Secretary for Programs, Research and Strategic Management of the National Justice Council. Advisor Gianni Bozotto, Advisor Márcio Luis Freitas, dear councillors, I would like to greet all of the members from diplomatic representations, chairpersons of courts of justice in Brazil, auxiliary justices, judges of the presidency of the National Court of Justice, uh, dear magistrates, speakers, ladies and gentlemen. I'd like to greet all of the participants of this international seminar, speakers and participants and our audience. I would like to announce that this meeting is the final result of a number of interinstitutional dialogues, as well as technical meetings and reports that were conceived and materialized in the European Union Brazil Exchange on the Expedience of Justice project that was coordinated by a delegation from the European Union in Brazil, along with the National Council of Justice. This project is mainly focused at establishing qualified dialogues among Brazilian institutions and European Union member countries about the digitization of justice-related services, understanding this development as an essential framework for the improvement in the efficiency of public services by using information technologies. Just as it happened in other stages of human and social evolution, just like the invention of the press by Johann Gutenberg in the 15th century, we're now equally living through an important development for society, which is the recent digitization and information support of our procedures, which positively impacts many productive sectors in the economy and provides for the creation of new businesses structures, in addition to its potential of improving the efficiency of public services. And within this contemporary perspective of digitization, the justice institutions and organizations are open to this initiative, directing the improvement of the speed of the services, aiming towards a completely electronic and digital justice. This impacts the way and the speed with which the information flows globally, facilitating the information flows among different communicators and reducing the costs, the institutional costs. And this is the foundation and the starting point for countless other opportunities in terms of services and applications of public services. So when we talk about new technologies such as the artificial intelligence and machine learning, or even blockchain, big data analysis, and cloud computing, we have to bear in mind that the use of these technologies will only be feasible and effective if there is a digitization and of information and digital storage of information, and these databases should be organized and structured for that specific purpose. This concern has guided the activities of this very fruitful partnership between the coordination of the works and under the coordination of the European Union in Brazil. During the thematic meetings and based on the report, we can see that the maturity and the degree of digitization and many countries like Estonia, Austria, Germany, and Brazil possess similar public policies aimed at the continuous transformation of the information flows in the respective countries, starting with the digitization of legal procedures and based on the efforts to reduce the use of paper, with the scope of developing a platform for electronic procedures with interfaces that would facilitate the end user's experience. We also have a vision for the great differential that the European member countries present on this context, which is the deployment of digital transformation technologies that are focused on the human being with ethical parameters and with respect to the human rights. From the Brazilian side, we can see that our major positive strength is the difference we've made in implementing digital public services in large scale, considering the need uh, to provide service to such a vast and territory with continental-sized country with so many uh, different differences among regions. So we have led the digital transformation program with the implementation of program Justice 4.0, and we have been making available to society at large a broad range of e-justice services that will be addressed in this present meeting. So these are the multilateral peculiarities that demonstrate the benefit of this sectoral dialogue that we are thus establishing with this partnership with the European Union in Brazil. And we have this convergence of efforts and this exchange of experiences and good practices. Throughout this seminar, we will present the main outcomes of the final report drafted by a team composed of a Brazilian expert and a European expert. Such an activity faced the challenge of addressing digitization not only from the technological standpoint, but also through the lenses of the potential benefits, while addressing themes dedicated to social protection, the protection of human rights, the use of technology for the prison systems, and the technological impacts of the protection of the environment. Lastly, I'd like to thank, as a chairman of the Supreme Court of Justice and the National Justice Council, for this unique experience of sharing experiences and exchanging experiences at the international level thus highlighting the importance of this initiative for us to have a more efficient judicial branch and more modern judicial branch, and above all, a justice system that should be accessible to citizens, as we all aim to implement. Thank you, and a good uh, meeting for all of you. We now give the floor to Ignacio Ibanez, Your Excellency Justice Luis Fuchs, President of the Supreme Court of Justice and of the National Justice Council, Justice Edson Fachin from the Supreme Federal Court, Humberto Martins from the Superior Court of Justice, and dear colleagues, ambassadors from the Netherlands, Ireland, Belgium, and from Luxembourg, and Minister Counsel from Spain, joint prosecutor from Union, Claudio Seffert, Augusto Aras, Secretary General from the CNJ, Special Secretary for Programs and Research and Strategic Management of the CNJ, Marcos Levius Gomes, dear justices, Brazilian and European experts, ladies and gentlemen. It is my pleasure to open today's seminar alongside Justice Fuchs and the other distinguished guests on this theme of electronic justice. After having led this project, Justice and Social Protection in the Amazon, I'm very happy to see the European delegation, its member states, and the National Committee of Jurists so that they can collaborate once again in e-justice. And dear Justice Fuchs, as you said, access to digital justice has been one of the main priorities of your mandate in the Supreme Court of Justice and the National Justice Council. Dear Marcos Livio, would like to thank you for your commitment in the drafting and execution of this project, and also big thanks to my team that has worked really hard in this project. I'm very happy to see that the last 6 months were very well used by experts from the National Council and from the European delegation so that we could lean upon our systems, particularly the e-justice systems of Austria, Estonia, and Germany. I'd like to greet the experts from the European Union, Mr. Christian Perron, Jordan Porsche, and Dr. Martin Schneider, who are with us today, both in person and online. I'd like to greet Mr. Eschwagnek from Austria, our dear colleagues from Estonia, Portugal, and Germany, which have enriched the discussions of the day with their experiences that have to do with digital file, environmental law, and prison administration, and so on. The visiting of justices and employees of the CNJ to Austria, Estonia, and Germany at the end of April was extremely useful and generated very fruitful discussions. Special word of appreciation to our hosts in Vienna, Hossendorf, and in Germany. And they confirmed that the visit of the Brazilian servants in the European Union can consolidate the strategic partnership with the Brazilian justice system and to promote new pathways for dialogue. Digitization of governance processes has been increasing in different spheres, including the judicial branch. The European Union, its member states, as well as Brazil, have started to take advantage of the positive aspects presented by the usage of e-justice and artificial intelligence tools. This trend has gained even more momentum during the COVID-19 pandemic and has led to a greater use of digital solutions by society at large and by national authorities. The European Union is committed to improve access to justice through the development of the European e-justice program, and we have adopted a strategy and an action plan. The program is called e-justice, and it encompasses the period to 2019 to 2023, through which the access to justice will be simplified and improved. In the period 2019-2023, the European program of e-justice will be focused on three main objectives. First, to improve access to information uh, related to justice. Secondly, to continue to digitize judicial and extrajudicial procedures to offer easier and quicker access to courts. Thirdly, to ensure the implementation and technical management of the electronic justice systems to facilitate the interoperability among the different systems of the member states.
Also provided is a set of measures to increase efficiency and efficacy of judicial cooperation, including cross-border cooperation. It might be obvious to most of us, but I still believe it is worth pointing out two aspects of e-justice that are fundamental for the European Union. First, the use of e-justice is also, if not mostly, a means to improve access to justice as a human right. This is another priority of the European Union and Brazil in the scope of our national strategy for human rights and democracy for 2020-2024. And by using e-justice systems, it is important to keep human beings at the center of our attention. Electronic justice allows us to be more efficient, but it also allows saving time and money. However, our efforts must be focused on how digitalization can benefit societies in the long term, concentrating on improving the quality of justice from the point of view of users. For instance, hearings by video conference must ensure that lawyers can speak confidentially with their clients during the hearings. The technical provisions in place for the use of video conferences must ensure a realistic experience, including communication and interaction between all the parties. And with all the benefits provided by technology, there is also a great responsibility in ensuring that the use of technology and justice will remain ethical, just, and focused on human beings. Computers cannot substitute human beings or judges or the contact between lawyers and their clients. It is extremely important for these considerations to be taken into account in the use of and development of AI. Changes must be introduced only if they improve rather than worsen the quality of our justice systems, and AI must be introduced only with the necessary mechanisms in place to ensure that no injustice will be done. Thank you. With the floor, Justice Edson Fachin. Justice Luis Fux, President of the Supreme Federal Court, my friend and colleague, also President of the National Council of Justice, Ambassador Ignacio Ibañez of the European Union to Brazil, Justice Humberto Martins, President of the Superior Court of Justice, Mr. Claudio Cifelde, representing the AGU Justice, Augusto Aras, Prosecutor of the Republic, Walter Schwenke, Secretary General of the National Council of Justice, Marcos Lívio Gomes, Special Secretary for Programs, Research and Strategic Management of the National Council of Justice, lecturers, national and international lecturers at this seminar on e-justice, a contribution to the strengthening of democracy and human rights. Ladies and gentlemen, council members of the National Council of Justice, ambassadors, and madam ambassadors, and representatives of courts, especially the regional electoral courts, justices, members of the prosecutor's office. The proposal of this event to foster discussion on the justice system using the knowledge produced in Brazil and the European Union is laudable and timely. We are facing very deep challenges, problems considered unsolvable, technically known as wicked problems, are affecting our social fabric and challenging institutions and the planning of policies. Issues are no longer limited by national borders. Now, the dilemmas are sustainability, in economic inequality, and equality in democracy. No country can address these issues alone. The world doesn't need walls. The world needs constructive dialogue, and nations need to move with collective intelligence, mutual cooperation, efficiency, and peace. The topics that cross-cut modern social relations, when they end in judicial conflicts, they require creative and technological solutions, which has been the mark of Justice Luiz Fuchs's administration as president of the Supreme Federal Court and of the National Council of Justice. We can be sure that technology that serves the issues of our time cannot be understood as an end in itself. It does not stand alone without the human element that confers purpose to it. The technology must be impregnated by humanity to improve people's lives and the delivery of justice. That's why, Mr. President and Mr. Ambassador, to have a seminar such as this is most welcome in discussing innovation in the Brazilian justice system and European justice system from the lens of human rights and democracy. Therefore, our sincere congratulations to the Embassy of the European Union and to the President of the Supreme Federal Court and of the National Council of Justice. We all know that democracy and human rights are unequivocally placed on the global agenda, and the democracy will ensure that justice must be speedy and inclusive. So we are not here by chance. The values that constitute the backbone of this cycle of debates unites at a higher level the National Council of Justice, the Superior Electoral Court, and the European Union. The TSE, the Superior Electoral Court, is closely connected with the CNJ, working on projects such as the one that creates the platform of the judiciary, and also with a view to the governance network. On the other hand, connection between Brazil and the European Union is long-standing, beginning with the construction of the political and cultural identity of our nation. And so several bilateral initiatives have been conducted with the exchange of researchers as well as joint action in international forums. Recently, for instance, the Superior Electoral Court and European Union launched an action to cooperate against the dissemination of fake news, which disturbs the expression of constitutional normality. And they have done so in order to share experiences on this matter, which is the fighting of disinformation. This is a battle to be fought with technology and with correct information. On this path, the TSE and the European Union have been developing studies and will publish the results of such technical studies with a view to improving mechanisms for dissemination of true information and fostering of plurality and respect for diversity. Brazil and the European Union share the principles of the rule of law and separation of branches and respect for human rights in times such as the current one, where these principles, even though paradoxically the conquests of liberal democracy are being questioned and challenged in several parts of the world. So it is not only desirable but necessary to maintain a firm position in favor of institutional stability, defense of liberties, and democracy itself. The promotion of democracy does not end at the geographic borders of a single country. The country, a democratic country, requires a democratic world. That's why countries and nations extend from the outside to the inside, from the inside to the outside, through inputs and outputs, consolidating an international community that is open and plural. That's why, President, Ambassador, I congratulate you and all those in attendance, and I hope that today's event will translate into one more opportunity to strengthen these ties, and the ideas that will be discussed here will serve to expand the horizons of cooperation in favor of justice, on behalf of justice. Thank you for your attention. I'd like to inform that Justice Luiz Fux apologizes but will have to leave now due to previous commitments.
Tem a palavra o ministro.
With the floor, Justice Humberto Martins. Good morning. Actually, good afternoon, ladies and gentlemen. I'd like to greet Justice Luiz Fux, President of the Supreme Federal Court and of the National Council of Justice. I'd also like to greet Justice Edson Fachin, President of the Superior Electoral Court. Also, my greetings to Cláudio Esfilder, representing the Justice of AGU. Also, on behalf of the Brazilian Prosecutor's Office, I'd like to greet the Prosecutor General of the Republic, Augusto Aras, who has been developing remarkable work on behalf of the Brazilian justice and citizenship. I'd like to greet Walter, Secretary General of the National Council of Justice, through whom I greet all the coordinators, organizers, advisors, and staff who participate actively in the holding of this seminar. Also, Marcos Lívio Gomes, Special Secretary for Programs, Research, and Strategic Management of the National Council of Justice, and also through Marcos Luiz Freitas, I would like to greet all the council members of the CNJ, friends, authorities, Bar Association of Brazil, Prosecutor's Office, and also friends of citizenship. I'd like to treat you all as friends, to address you as friends. In this seminar, I must say that we are still, well, we are still experiencing anxiety, but we are soon to experience better times in this hybrid event, right? We know that everything passes, everything but the love of God. God is with us. We have missions, and we need to develop our talents. We cannot just as fucking bury them. We need to develop them.
so that we can do good and administer justice. And I understand that with respect to the law and the Constitution, we should work towards the strengthening of the rule of law with equality and fraternity. With great joy, I today participate in this opening of the international seminar, Brazil European Union, the exchange of experience in e-justice. And also, we are presenting the program Justice 4.0, organized by the National Justice Council in a partnership with the European Union delegation in Brazil, aimed at analyzing the pathways of e-justice and with the purpose also of establishing this dialogue between the European Union and Brazil. Once again, I would like to thank the Justice and President of the Supreme Court of Justice, Supreme Federal Court, and President also of the National Justice Council, Luis Fux, to participate in the ceremony and to say a few words about the importance of this topic, as well as to brush over a few topics on this program. I would also like to take the opportunity to pay homage to all of the members of this official opening panel on behalf of Edson Fachin, the President of the Electoral Court of Justice. On his behalf, I would like to greet all of the other members. This is a moment for an opportunity at the National Justice Council and the delegation of the European Union in Brazil provide to Brazilian justices and magistrates and the legal community at large so that we can exchange experiences and work towards the dissemination of legal cooperation, international legal cooperation, at the level of the member countries of the European community. Likewise, to discuss the topics in such a high level fashion makes it all it more efficient when we have speakers as distinguished as the ones selected for this international seminar. I am certain that this meeting will contribute a lot with the strengthening not only of the Brazilian judicial branch, but would also improve the exchange of experiences that are related to e-justice, especially in terms of the partnership between Brazil and the European Union. Technological transformation has been undertaken by the National Justice Council, and this has led the Brazilian judicial branch to the forefront of the global digital transformation initiatives, so that these serve as an inspiration to other countries in the world. In the same tone, the innovation and best practices developed in Europe, among which we can highlight Estonia in its experience, Germany and Austria, have certainly contributed for the improvements that we can now see in the Brazilian justice system because of the partnership that we have, because we have today a more efficient, qualified uh, justice service. So the dialogue among countries with the effective cooperation among institutions and with the fostering of innovation, all of that will allow us to progress together with convergent efforts towards the strengthening of the judicial branch, especially in the digital context, in which the technological development takes place at an exponential pace, which requires from us a lot of agility so that we can keep up with the demands of society and the modern world. I would like to close by congratulating all of the participants of this seminar. Let us have faith in justice, in democracy, democratic institutions, and in people. May God bless all of us. If we have a strong legislature or if we have strong justices, we have a strong country. Brazil and European Union. Together we are stronger. Thank you all. We now give the floor to Dr. Claudio Serrefelde. Good afternoon, everyone. Dear Justice Edson Fachin, President of the Superior Court, Electoral Court, and member of the Supreme Federal Court, Ambassador of the European Union, Ignacio Ibanez, the President of the Superior Court of Justice, Humberto Martins, Augusto Aras, Prosecutor General of the Republic, Dr. Walter Schwen, and Marcos Livio. To the Attorney General's office, it is a great reason for pride for being here, because it is fundamental to have the collaboration of the litigants and the union, even though it has a lot of efforts to reduce number of procedures. It's a great litigant, and we are trying to reduce the level of idleness because of the respect of to the proceedings of the Supreme Court of the SDJ, Superior Court of Justice, and making a selective execution of debts that were not assets to improve. And we have been trying to implement conflict resolution, alternate conflict resolution systems. But it's important to see in events like this how other countries are dealing with electronic justice, with e-justice, which is even more relevant after the pandemic. And we are at your disposal so that we can contribute in the Attorney General's office for the federal government. Just a few figures to show you the size in the sheer number of procedures in the federation. We consider the whole of the federation: 75,000 daily subpoenas, 3,100 subpoenas per hour. So we have in our systems thousands of procedures, 10,000 new lawsuits against the federation. By every day we are integrated to 370 courts, 7,000 simultaneous users using the system. So the system is called Sapiens. We have over 1 billion documents annexed, attached to this model, and over 40 million procedures involving the union. So it is very relevant. The result of an event like this is very relevant for us, so that we can contribute with the improvement of the e-justice. And I would like to thank and congratulate you all and wish you all a great event.
Da palavra, o doutor Augusto.
We now give the floor to Dr. Augusto Aras. Good afternoon, everyone. I would like to greet Justice Luiz Edson Fachin, President of the Electoral Court and also Justice of the Supreme Federal Court, Ambassador Ignacio Ibanez, Ambassador of the European Union in Brazil, His Excellency Humberto Martins, President of the Superior Court of Justice and the National Justice Council, and Dr. Claudio Serrefelde, Joint Attorney General of the Union, here representing the Attorney General Bruno Bianchi, Dr. Walter Schwinkner, Secretary General of the National Justice Council, and Dr. Marcio Livio Gomes, who has just left. He had an urgent appointment, and I'd like to greet all of the councillors of the National Justice Council, especially Dr. Marcia and Councillor Marcio Luis Freitas. And I'd like to greet the members of the different diplomatic representations here present, presidents of courts, auxiliary justices of the presidency of the CNJ, dear magistrates, attorneys, colleagues from the Federal Prosecution Service, the speakers who have come to share their experience with us. Dear friends, I'd like to congratulate the initiative uh, 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 of our dear Luis Fux because of the advancements this brings to the Brazilian judicial system in terms of technology and innovation, as well as this exchange of experience with the European Union on e-justice and how much we can advance because of that in our legal international cooperation. Access to justice facilitated by technological innovation is already a reality in the Brazilian Federal Prosecution Service, and we work together with the judicial branch for its constant improvement. Technological improvement should be sustainable and capable of creating a quicker, more economical and effective service provision, which is one of the objectives, strategic objectives of the Federal Prosecution Service in Brazil. We have recently advanced even further in that purpose with the project Governance of Data and Digital Transformation in the Federal Prosecution Service, established in 2021 by the National Council of the Federal Prosecution Service, and we have intensified our efforts in that direction, especially after the COVID-19 pandemic and the uh, the massive adoption of the remote work, uh, which allowed us to perfect uh, remote tools of work, which was a challenge not only because of technological challenges, but because of our continental size. The implementation of systems is not easy in our country, considering the size of Brazil and our federative regimen, which, at the side of the principle of functional independence of courts, it demands institutional arrangements that today are only possible thanks to organizations such as the National Justice Council. In these headquarters and in the National Federal Prosecution Service, uh, uh, that it's just near this building. These are organizations that are working in harmony with our principles of autonomy, independence, and unity in the broader sense of the federative organization and in the specific sense of the organization of the judicial branch and the Federal Prosecution Service. We are always protecting the safety and transparency of information. In the Federal Prosecution Service, we see that materialized in our unified system, a technological tool which deals with over 2 billion procedures a year. And through this tool, we have a connection with systems of 35 different courts of our country through the national interoperability system, which actually integrates many different institutions of the judicial branch. The other example of that is Luna, a system for warnings of professionals about the COVID-19 pandemic created in 2021 for the exercise of medicine in every single institution of the country in which the Brazilian system was overwhelmed by the sanitary crisis. This platform, Luna, was very important so that the Federal Prosecution Service, the courts of justice, and all of the similar institutions could provide a contribution in different moments of the most serious sanitary crisis of the last 100 years. This is a fruit of the cooperation between the integrated cabinet of follow-up of the pandemic, the Federal Prosecution Service, the National Council of the Prosecution Service, and the Medicine Council. Cooperation is a key for all of our federative agreements and arrangements and republican arrangements in which our institutions have an independent and harmonious cooperation. So we have sovereign partners which exchange experiences and provide legal international support. I would like to highlight that the presence of the Attorney General's representative here is very significant because uh, the AGU has been looking for extrajudicial uh, conflict resolution system. Is our major client. 70% of our procedures are interesting of special interest of the federation, and this improvement of extrajudicial means of conflict resolution associated to digital modern systems will certainly provide greater speed so that we can comply with the rule of the natural delay of the process. The process should not be a burden in itself. So I'd like to close by saying to all of you, ladies and gentlemen, that the Federal Prosecution Service is always trying to improve uh, in the connections that we maintain with distinguished institutions, both national and international institutions. So we have better access to justice in Brazil and abroad, so that the Federal Prosecution Service can comply with its federal with its constitutional agenda. Thank you very much, and I wish you a great success. And the seminar is already a major success. Thank you.
Ladies and gentlemen, we would like to thank you all for your opening remarks, and we will now have our lunch break. So have a great afternoon.